ये मैटर जो मैं आपको बोलने जा रहा हूँ, आप इस मैटर को हमारे सॉफ्टवेयर पे टाइप करके आप अपनी मिस्टेक्स को जान सकते हैं और अपने शॉर्टहैंड को इम्प्रूव कर सकते हैं, जिसका लिंक मैंने अपने डिस्क्रिप्शन बॉक्स में दे दिया है।
Get ready, start. It is further submitted that the intervener is being unnecessarily suffering because of remaining amount not being paid by the appellant. Stop. It is also case of the intervener that as per the emails exchanged between them which have been duly placed on record prior to the undertaking dated 3/7/2018, it was decided and agreed between them that the amount would be paid as per their respective shares, that is, in the ratio of 60/40. Stop. The said exchange of emails and the draft settlement was also shared with the lawyer and the same was duly accepted. Stop. The intervener was not dealing with the lawyer directly and it was the appellant who was dealing with the lawyer. Stop. The appellant with the lawyer directly and it was the appellant who was dealing with the lawyer. Stop. The appellant has mischievously and fraudulently altered the words as per the respective shares by substituting it with equally. Stop. The intervener was hurriedly made to sign the undertaking on the date when it was being filed and he trusted the appellant and the lawyer who was appearing for both of them. Stop. It is further stated that the intervener has also filed before the High Court by way of a modification application to deal with this aspect of the matter, which application is still pending. Stop. Para. We have perused the undertaking dated 3/7/2018 as also the order dated 3/7/2018 and also the subsequent orders passed by the High Court. Stop. It is apparent for the same that the complaint was entitled to receive a total amount of rupees 4,63,50,000. Stop. The undertaking, as also the order dated 3/7/2018, clearly mention that both of them will pay the amount equally as agree by and between them, and it further contains a stipulation that in default of the payment by either of them as per their, and it further contains a stipulation that in default of the payment of either of them as per their agreed share in the settlement, they shall be held liable and prosecuted as per law. Stop. The settlement between the two directors, that is the appellant and the intervener, is inter se these two only, and the complainant is not bound by the same. Stop. Complainant's agreement or consent was only to the extent of accepting rupees 4 crore 63 lakh 50,000 only. Stop. He was only a signatory to the agreement which was signed by the two parties. Stop. Admittedly, both the appellant and the intervener were chairman and vice chairman of the company and therefore were convicted by the trial court, and their conviction was affirmed by the appellate court. Stop. We are not inclined to go this question as to who is to pay how much amount. Stop. The fact remains that the total amount agreed to be paid has not been paid, and as per the order of the High Court dated 23/2019, the revisionists, being in default in payment of the agreed amount, the interim protection granted by way of bail and suspension of sentence would stand withdrawn without reference to the court. Stop. We find no infirmity in the impugned order. Stop.